Okay, let's dive into a huge legal battle that actually redefined copyright law. And you know what? It all started with something most of us have probably forgotten about, the humble phone book. Yeah, that massive brick of paper, just full of names and numbers, sparked a fight that went all the way to the highest court and completely changed how we think about information itself. So right off the bat, here's the central puzzle. Can you actually copyright a simple list of facts? I mean, it seems a little weird, doesn't it? How can you own information that's just out there, publicly available, like names and phone numbers? Well, the legal answer is a lot more complex and honestly more surprising than you might think. To really get this, we've got to take a quick step back and look at the core purpose of copyright. See, it isn't some blanket protection for any kind of work. It's specifically designed to protect original expressions. Things like novels, songs, paintings. The whole point is to reward creativity, not just the fact that you worked hard. In this right here, this is the fundamental battle line in copyright law. On one side, you've got original expression, the creative stuff, and on the other, you have mere information, just raw facts, data, or in our case, a phone directory. The entire legal challenge, really, is figuring out where to draw that line. If you take away only one thing from this whole explainer, let it be this word, originality. It's the absolute non-negotiable bedrock of copyright law. Without that little spark of creativity, all you really have is a collection of data, and it doesn't matter how much effort it took you to put it all together. So, how do courts actually test for this originality thing? Well, a perfect example comes from a real-world legal showdown in Australia's High Court, a case that hinged entirely on, you guessed it, the humble phone book. The case, which happened back in 2010, was Telstra versus phone directories. So Telstra, the telecom giant behind the iconic Yellow Pages, claimed their directories were protected by copyright. This move basically put the very definition of an original work on trial. Was a simple, alphabetical list of data creative enough to qualify? That was the big question. Now, Telstra's argument was pretty straightforward, and, on the surface, it sounds really compelling. They basically said, look at all the work we did. We spent a massive amount of time, money, and resources to collect, verify, and organize every single name and number in this book. That effort has to be worth something, right? Their entire argument was resting on this legal concept known as the sweat of the brow doctrine. And it's exactly what it sounds like. It's the idea that copyright can be earned through sheer effort and diligence alone, the sweat of collecting facts, even if there's no real creative input. And this brings us right to the core legal question the court had to answer. Is sweat enough? Can you copyright something just because it was incredibly difficult and expensive to create, even if the final product is just a straightforward list of facts? So the stage was set for a truly landmark decision. The court's ruling wouldn't just affect phone books. It was going to set a major precedent for how copyright law applies to all kinds of databases and data compilations, especially in the digital age. And the verdict? Well, it was a bombshell for that whole sweat of the brow argument. In a really clear and decisive ruling, the High Court declared that Telstra's phone directories were not protected by copyright. Period. So why? What was the court's reasoning? Well, it was crystal clear. First, they said the directories just lacked true originality. The court saw it as industrious collection, not creative skill. And in doing that, they flat out rejected the sweat of the brow doctrine. The message was simple. You cannot use copyright to put a lock on pure information. And there's this one quote from the ruling that just captures the logic perfectly. It says, copyright protects original skill and labor, not mere information or sweat of the brow alone. It really couldn't be any clearer. It's about that creative spark, not just the hard work. Okay, so a case about an old phone book from 2010. Why are we talking about this now? Why does it matter? Because the principle it established is more relevant today than ever before, especially in our digital world. So the single most important takeaway from this whole story is this fundamental distinction. Effort is not the same as originality. Spending 1 million hours on a project doesn't automatically make it creative, and copyright law cares about the creativity, not the hours logged. And this principle is now the bedrock of our digital age. It applies to the massive databases that power our apps, the huge data sets used to train AI, and really any project that's built on just compiling facts. This ruling is why raw data can remain in the public domain, which is great for competition and lets smaller innovators build on existing information without being blocked by huge corporations.
And all this leaves us with a huge question for our time. As AI gets more and more sophisticated at creating content, how are we going to define originality? Where is that line between true human creativity and just an advanced compilation of data? The phone book case gave us a vital principle, for sure, but figuring out how to apply it in the age of AI, well, that's the next great legal frontier.